You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 56. What are continuing patent applications and do I need to file one? My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Or if it's too hard to remember, you can get to it through patentingforinventors.com. That's patentingforinventors.com, or call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state, so feel free to contact me regardless of where you live. This episode is about continuing patent applications. There are different kinds of continuing patent applications, and at first I was going to talk about all the different kinds of them in one episode, but as I was writing up what I was going to talk about, there really was too much information to keep the episodes between 5 and 15 minutes, which is what I like to do. So this is just going to be a general overview of the purpose and the main kinds, just a brief introduction of the continuing patent applications. And for the most part, continuing patent applications are filed to cover new aspects or improvements to your invention that's related to an earlier application that you filed. There are between 3 to 5 different kinds depending on how you want to classify them. There's something called a divisional application, a continuation application, and a continuation in part application. These are the main 3. Very briefly, because I'm going to go over each of these in a separate episode, a divisional application is done if you are forced to divide up your first application because the examiner felt that you had more than one invention in your patent application. A continuation application is done if you want to cover aspects of your invention that you weren't able to get with your first patent application. Usually it's if you want to broaden your patent rights for the same invention that you got a patent for, but there are other reasons too, and I'll go into more details in that and in that specific episode about continuation applications. The next kind is a continuation in part application. This is similar to a continuation application, except that you're adding new subject matter to it. Let's say you filed an application, and then after you filed it, you realize that you forgot to describe something or provide some illustrations of a version of your invention, and you think it's really important. Oftentimes, you can't get patent protection for that new variation with your first application because you didn't discuss it in your first application, and you can't add new matter to an already filed application. So you have to file a new application, and that's when you file a continuation in part application. So those are the main 3 kinds of continuing patent applications: divisional, continuation, and continuation in part applications. There is another one called a reissue application, which is a little bit different. These can get kind of tricky, but essentially what happens is that you get your patent issued, but then you realize you made a mistake in that application somewhere. There are lots of rules on what you can and can't do. So you can file a reissue application to correct those mistakes. Sometimes you can get a reissue to broaden your patent protection, but sometimes you're not allowed to broaden it, but only make other types of corrections. And I'll go into those rules when I get into reissue applications. If you get your reissue patent granted, it replaces your original application, but if it doesn't get granted, you still have your original patent that is enforceable. The other kind of continuing patent application is a little different also, and it's only for design applications, and you can't do these anymore for utility applications, and it's called a CPA. CPA does not stand for continuing patent application, it stands for continued prosecution application. So don't get confused when I say continued patent application, even though it has the same initials. A continuing patent application is not a CPA. A CPA is a continued prosecution application. What this means is that you want the examiner to keep examining your design application even though it's received a final rejection. Technically, it does receive a new application number, but it's not so much of a new application as it is with utility patents, but you're generally just trying to still continue to argue to the examiner that your original design in your first application should still be allowed. In utility applications, a similar type of thing is called a request for continued examination, but for design applications, it's called a continued prosecution application, or a CPA. So I've talked about all these kinds of continuing applications and that they're somewhat related to your original application that you filed, but why do you actually need them? Why can't you just file a new application and just not even mention that you had filed another related application? The reason almost always comes down to getting an earlier filing date. There are some tricky things with continuation and part applications related to getting an earlier filing date, but for all the others, if you file one of these continuing applications It's as if you had filed that application on the date of your earliest application. So if you had filed your first application on January 1st, 2018, and then you filed a continuation application on January 1st, 2019, 1 year later, it's considered as if you had filed that second application on the January 1st, 2018 date. Now, why is this important? Because if you didn't file your new application as a continuation application, but just as a regular new application, anything that came out, such as competitors' products, between January 1st, 2018 and January 1st, 2019, could be used against you, and your application could be rejected. But since you filed it as a continuation application, only things before January 1st, 2018, that first application you filed, could be used against your new application. I'm going to go into more details in each of these episodes where I talk about the different kinds of continuing applications and what situations they're useful for. But for now, just know that if you want to get patent protection for something similar to what's claimed or described in your first application, there's a good chance that you might want to file some type of continuing patent application. Now, if you want help with your patent application, you can contact me through my website at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.